Hello America, welcome back to my channel. Today we're going to sue the state for Second Amendment violations. I am Bear Arms and today is 22 August, the year 14 after Bitcoin. This is a sample lawsuit of an action for declaratory judgment according to 28 U.S.C. 2201. This action is available to almost anyone, including out-of-state residents, non-violent convicts, and even non-Americans. This action is a suit against Massachusetts executive agencies, and the principles apply to any other state or the federal government, including the ATF and the DOJ. You may download this PDF with a Google Drive link, sign your name, and file away. The theory of the action behind this suit is that the executive branch is breaking the law. It's depriving our rights secured by the Constitution under color of professional licensing contracts. It's exceeding its legislative authority to regulate. It's willfully failing to faithfully execute the laws. It's violating the State's Administrative Procedures Act. It's violating the Separation of Powers Doctrine. And it's committing fraud on the court, which makes the court not even a court. Finally, it is subjecting us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, and prosecuting us under acts of pretended legislation for transporting us beyond seas into maritime admiralty jurisdiction to be tried for pretended offenses. Please reference the Declaration of Independence. The strategy that we will employ is that we will sue the executive branch vested with the power to regulate firearms for declaratory judgment. In Massachusetts, that's the Executive Office of Public Safety and Security, also known as EOPS. We'll use the Federal Rules of Civil Procedure for EOPS to admit that they have the authority to regulate firearms for employment, for hire, for reward, or for business purposes. We'll use Federal Rules of Procedure for EOPS to admit that there is no authority to regulate the right of the people to keep and bear arms for personal use. And we'll use Rule 34 for EOPS to show that no legislative authority exists for regulation of people to keep and bear arms. And we'll use Rule 56 for summary judgment against EOPS for declaratory judgment under 28 U.S.C. 2201. Here it is. Bear Arms versus EOPS and AGO of Massachusetts. That's the Attorney General's Office of Massachusetts. This is the caption. In the United States District Court for the District of Massachusetts, Bear Arms is plaintiff, the EOPS and AOG are defendants. It is an action for declaratory judgment. And it begins. I am Bear Arms, one of the people of the several states which are united by and under the Constitution. I appear in my proper person to seek declaratory judgment in a case of actual controversy arising under the Constitution, and so forth. Then it goes on to describe who the defendants are, including a snapshot of the state's statutory scheme for firearms licensing as described by the Supreme Judicial Court in Chardin versus Boston Police Commissioner. And here's the Office of the Attorney General, who is also a defendant. Then we describe the venue, forum, and jurisdiction. The venue is the United States District Court for the District of Massachusetts. The jurisdiction is federal question jurisdiction under 28 U.S.C. 1331, and it's for a declaratory judgment under Section 2201. Then I go on to describe what actual controversy is, that it has arisen because defendants and their employees are threatening me with seizure of private property, arrest, and prosecution if I were to exercise my constitutionally secured individual right to keep and bear arms for personal use in Massachusetts without first obtaining a license to carry firearms. The standing and ripeness requirements of jurisdiction are met according to Susan B. Anthony List versus Dryhouse and Pierce versus Society of Sisters, which are two Supreme Court cases, basically saying that it is not necessary that I first expose myself to actual arrest or prosecution to be entitled to challenge a statute that I claim deter the exercise of my constitutional rights, so that pre-enforcement review may be had under federal question jurisdiction. Furthermore, should the Attorney General's Office or their agents prosecute me for keeping and bearing arms without a license to carry firearms, the judicial power of the United States would not protect me. And that's according to 28 U.S.C. 2283 and also the Younger Abstention Doctrine. The declaratory relief is what I am seeking, and I'm seeking it based on the fact that the defendants are depriving my rights under color of law by misconstruing and misapplying the licensing scheme, which was enacted to regulate public safety and security professionals. I am entitled to this declaratory relief because I am entitled to know the limits of the state's regulatory authority and to find my security in the laws. Now, here's a very important point. Where each allegation is not denied by the defendants, they are admitted in accordance with Federal Rules of Civil Procedure. Allegation number 1. The law provides that the application fee for a license to carry is payable to the licensing authority, and the licensing authority is one with the authority to impose an occupational fee or a licensing requirement on a profession. But a state may not impose a charge for the enjoyment of a right granted by the Constitution. Therefore, there is no fee for the right to keep and bear arms for personal use. And where do we see these laws? Right here. Mass General Laws, Chapter 6, 172N. The licensing authority is one with the authority to impose occupational fees or licensing requirements on a profession. Where does it say that they have the authority to impose a fee on your right to keep and bear arms? It doesn't, does it? Allegation number 2. 803 CMR 2.01 is a regulation that provides the purpose and scope of the Criminal Offender Record Information Background Check. And guess what the purpose is? It's for employment, or volunteer opportunities, or professional licensing. Where does it say that you need a background check to enjoy your right to keep and bear arms under the Constitution? Again, it doesn't, does it? Allegation number 3. Mass General Laws, Chapter 6, Section 172B.5 requires applicants for licenses in specified occupations to submit a full set of fingerprints. So fingerprinting is required to carry firearms in an occupation. But where is the law that imposed the submission of fingerprints for the enjoyment of the right to keep and bear arms for personal use? It doesn't say that, does it? So why would you submit your fingerprints in order to keep and bear arms under the Constitution? Here's the law. You can go read it for yourself. And just ask yourself the question, what part of this law infringes on your right to keep and bear arms? Okay, allegation number 4. The EOPS is empowered by statute to regulate officers, employees, private investigators, security guards, and other persons whose profession or occupation requires them to possess or carry firearms. But there is no legislation authorizing them to regulate or to license the right of the people to keep and bear arms for our own personal use. If such power ever existed, then under the Major Questions Doctrine, the EOPS must point to clear legislative authorization for the authority it claims. See West Virginia versus EPA. Allegation number 5. The district attorneys are empowered to protect the people by prosecuting crimes. But if the EOPS does not institute or recommend institution of proceedings in a court pursuant to the Administrative Procedure Act, the Attorney General's office and the district attorneys may not assign the enforcement powers of a regulatory agency to the judicial branch, in violation of judicial independence and the separation of powers doctrine, because that violates the law. Allegation number 6. Failure to make EOPS a party or preventing it from being heard in the prosecution of a victimless regulatory licensing offense would deprive a trial court of competent subject matter jurisdiction and would violate Mass General Laws 231A, Section 8, in which any proceeding which involves the validity of a license or other privilege granted by the Commonwealth, the agency granting the privilege shall be made a party and shall be entitled to be heard. Allegation number 7. The Mass General Laws provides that a license shall entitle a holder thereof to possess and carry firearms. Now these are statutory entitlements, that is, to possess and carry are different from the rights secured by the Constitution. In fact, carry means the duties and functions of public offices, to carry on a business, and to carry weapons by police officers, sheriffs, deputies, correctional officers, watchmen, guards, private security guards, patrolmen, detectives, and investigators in the performance of their duties, to protect persons or property for hire. That's what the word carry means. We know this because if we do a word search of the Mass General Laws for the word carry, we see to carry out the state environmental policy, to carry out their assigned duties, to carry out the functions of a public office. For example, carry out the provisions of this chapter, the functions, powers, and duties of this commission, to carry on the business as a gunsmith or a retailer to sell, rent, or lease firearms, to carry out the powers and duties of police officers and weapons on official business. Sheriffs, his deputies, corrections officers, and other officers may carry police weapons in the performance of their duties. Licensees who serve the public are to carry firearms in the performance of his duties, and security guards who carry firearms are doing so in the performance of their duties. That is to say, carry and possess are statutory entitlements, whereas to keep and bear arms is a constitutional right. Carry may mean to carry on the powers, duties, and functions of public office, but no law equates the licensed entitlements to carry and possess firearms with the right to keep and bear arms. The law is the definition and limitation of power, and thus far we have not traveled in our search for the meaning of the lawmakers beyond the borders of the statute. And while the state may impose licensing requirements to possess and carry firearms for the performance of duties, for hire, reward, or a business, there is no such thing as a license to keep and bear arms for personal use. Allegation number 8. The Mass General Laws provides punishment for the unlicensed possession of statutory firearms, that is, those defined in Section 121 of Chapter 140. Firearms and other items so defined are those that are found in retail gun shops, gunsmith offices, carried as duty pistols by police officers and security guards in the performance of their duties, in other words, duty guns, firearms with defaced serial numbers, and firearms discharged within 500 feet of a dwelling. And these statutory firearms excludes arms that people keep and bear as private property. That is to say, statutory firearms excludes arms in the defense of his property, described in Chapter 149, Section 177, and also firearms or ammunition, described in the hunting and fishing chapter of 131, including a shotgun, any rifle, or any revolver or pistol referenced in the general laws. Statutory firearms also exclude arms for personal use, military arms, uniforms, and equipment, which the people have kept with so much of their fuel, provisions, furniture, and personal effects in his household, livestock, poultry, and utensils for household keeping necessary for upholding life, since such law was first passed in 1786. Here's the law from 1786, which basically describes arms and categorizes them along with household utensils, tools, or implements for trade, beasts of the plow, livestock, bedding and wearing apparel, and other household goods. The date of this law was first passed in February of 1786, and it's still good law to this day because here it is in Chapter 60, Section 24. The words are almost exactly the same, except arms have been converted into military arms, uniform, and equipment. So in those 200 years, we have arguably expanded the definition of arms to include not only what one would use for personal use, but also military arms. Here's another part of the same law from 1786, now codified at Chapter 62C, Section 55A, Arms for Personal Use. I've made this Venn diagram to sort out the difference between arms and firearms. Notice that all firearms are arms, but not all arms are firearms. And the Constitution divides arms into two distinct groups, those that people keep and bear, and all other arms. On the right-hand side of the screen, you'll see that all other arms include the statutory definition of firearms in the state law and in federal laws. They are subject to the government, they do not belong to the people, they are defined by the statute, they may be licensed and restricted, and thus may be infringed. On the left hand of the screen, you'll see the arms that people keep and bear codified in the Mass General Laws, such as arms for personal use, military arms, arms in defense of property, and arms required to aid officers. Those arms belong to the people, they are not defined by statute, they are not licensed, they are not restricted, and they are exempt from tax, levy, and seizure. In other words, they shall not be infringed. Thus, your arms for personal use are not firearms. Always bear arms. Never carry a firearm except for duty or for hire. Allegation number 9. The individual right to keep and bear arms for personal use, for the defense of his property, for the common defense, and the security of the free state is guaranteed by the plain text of the state laws, the Massachusetts and federal constitutions. This right is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument, nor the license to carry firearms for its existence. Finally, it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. This is the very essence of judicial duty. And when a person cannot know how a court will apply a settled principle to a recurring factual situation, that person cannot know the scope of his constitutional protection, nor can a policeman or a prosecutor know the scope of his authority. Wherefore, I, bear arms, plaintiff, pray for a declaration and judgment holding each of the foregoing allegations 1 through 9 to be true. Very respectfully executed. Bear arms. Now, when you file this lawsuit, you're going to request admissions under Rule 36. That means you will request that the defendants admit that the license to carry firearms is for professional licensing required in specified occupations, subject to an occupational fee. They will admit that the right of the people to keep and bear arms is not in any manner dependent upon the license to carry firearms for its existence. They will admit that the licensed entitlement to possess or carry firearms may mean to carry firearms in the performance of duties or to carry for reward or for hire. They will admit that the statutory definition of firearms excludes arms for personal use, arms in defense of property, and military arms for the common defense. They will admit that there is no such thing as a license for the right to keep and bear arms for personal use. They will admit that a district attorney who prosecutes a regulatory crime in the absence of the regulatory agency and without a permissive statute conferring competent subject matter jurisdiction violates 1. The Separation of Powers Doctrine, 2. The Administrative Procedure Act, 3. The Declaratory Judgment Act, 4. The defendant's right to be tried in a court of law having competent jurisdiction, and 5. That they are committing fraud on the court. Then you'll request, according to Rule 34, for them to produce any law that shows that the license to carry firearms is anything other than a contract with the government for an entitlement. Make them show you that there is a law requiring the people to contract with the government for an entitlement in order to exercise a right secured by the Constitution, which does not exist. Make them show you the law that the license to carry firearms is anything other than a professional license required in specified occupations. Make them show you the law that requires a license for the right of the people to keep and bear arms for personal use, or to keep military arms, or to keep arms in the defense of property, or arms to aid magistrates and officers, or arms for the common defense, or arms for the security of the free state, etc. Those laws do not exist. Make them produce any law that authorizes the district attorney to prosecute a regulatory crime for unlicensed firearms possession in a court of law in the absence of the regulatory agency, and make them produce the law that confers the regulatory enforcement powers of an executive branch agency to the judicial branch of government. None of these things exist. So what do you do from here? Well, first of all, if you're ever called to be a juror, you can nullify any unlawful or unconstitutional gun law in which there is no victim. In other words, if there is no victim, there is no crime. You are the lawgiver in that situation, and you have an absolute right to nullify any unconstitutional gun law as a juror. Number 2, assert your constitutional protections by invoking the power of its terms. Always keep and bear arms, but never possess or carry firearms unless it's for the performance of your duties or for hire. If you're feeling bold, join the lawsuit, download the linked PDF, sign, file, and serve. Study the law of your own state and of the United States, and sue them too. Bear arms, America, because law secures liberty without license. Thank you for watching.